Hello, my name is Victor Chen.
I'm Bruno Mendez with Mendez Wealth Management.
Yes, we're going to continue our chapter 3. Chapter 3 is a little confusing, and it's very important parts. We call the chapter 3 is called property encumbrance. Property encumbrance means that anything will affect the property. When you own the property, probably a lot of people will jealous you. They try to sue you or try to get rid of you, try to take advantage of you. So you have a watch this encumbrance, which is will affect your property. The first part is called the non-money. Non-money, that means those only affect your right and not nothing to do with the money. The second part is relate to the money. That means that the lien or somebody will sue you, and you become some trouble with it's relate to the money. Okay. In the first part, which is non-money, we have three different parts. One is called the easement. The easement has to cover quite a few things. One is a dominant, servant easement, conservative easement, by prescription, engrossed, license, terms, apartments, and profit. So we can discuss one by one. Okay, one by one. Yes, please.
And non-money encumbrances are encumbrances that affect the physical condition or use of the property. These are easements, building restrictions, and zoning requirements and encroachments. A buyer will commonly accept a deed to encumbered property with the price adjusted accordingly. Often the encumbrance is not objectable. For example, an easement for utility wires, but sometimes a buyer may insist that the encumbrance be removed or cleared from the public record before the transaction closes. Number 1, easement. Easements, probably the most common of this category, are ordinarily rights to enter and use another person's land or a portion thereof within definable limits. Therefore, an easement is a right or privilege or interest limited to a specific purpose which one party has the land of another. Dominant tenant. Easement rights are often created for the benefit of the owner of adjoining land. The benefited land is called the dominant tenement. Servient tenement. Easement rights are often created for the benefit of the owner of the adjoining land. The benefited land is called the dominant tenement, and the land subject to the easement is described as the servient tenement.
Okay, the terms is very important. It must be memorized. Okay, let me show you the sample. If you have a land, they have a house here. Okay, in the back house, right now they have a usually if the land is big enough, usually the front house and the back house. Okay, this is called, and in the back house, they have the right to access to the back to his property. However, this part, the land, is belong to the front house. Okay, so the front house's land was used by the back house owner, right?
Yeah, and legally.
So this is called the dominant. This is called a servant. Remember, this is very confused, and they will call you, your property is being used by somebody else, well, you are the servant. Okay, and you use somebody else's land, you are the dominant. Okay, so this is the first, they will call you, they will test you that did you memorize the term of the position.
Yeah, that's very important, especially in California.
Right. Okay.
And conservation easement. An easement whereby the landowner must retain the land in a natural or agricultural state. A conservation easement is normally purchased by a nonprofit organization. Easement by prescription, also called adverse possession. Continuous and uninterrupted use for 5 years will create an easement by prescription where such use is hostile and adverse, without license or permission from the owner. Open and notorious. The owner knows of the use or may be presumed to have noticed the use.
Okay, so this is a very important concept, legal terms. You need to memorize. That means that your right, this is your property. Okay, this is your neighbor. This is your neighbor. Usually have a shortcut, the road to them, but sometimes they have another road. Another road they need to go down the way back to him. Okay, so they have a 2 roads to get in the neighbor. This is the neighbor. This is the front. Okay, so this is the shortcut. Okay, so this is for the back house. They're using the road, shortcut road to back to his house. He needed to using the front house land, right? Right. If the front house give the right to use, so this is called easement. If they just say no, I don't want you to use my right, so I'm gonna put a chain lock here, so you cannot cross that. So he tried to when the front house owner is not in home or vacant, so the back house they open the lock and using the entrance
Right.
to back to his house. Okay, this is called if they continue to use as this way as a time, continue for 5 years. Okay, then this right will become a permanent.
Oh, well.
Okay, so this is a very, very important. This is the 2 kinds. One is called a prescription. This is called a prescription. They just take the use right. But if the back house, they pay the property tax for the front house for continue for 5 years. That means this is a vacant. Nobody take care of that. So the back house, they can legally claim the ownership of the front house
After 5 years.
after 5 years. This is called advanced possession.
Wow.
Adverse possession. So this is a very, very, very important legal concept. So you need to memorize.
All right. And next one is going to be easement and gross, also utilities. Public utilities frequently enjoy easement to erect poles and string wires over private lands, yet own no related dominant tenement. Such easements are technically known as easements in gross and are personal rights attached to the person of the easement holder and not attached to any specific land. Yet in reality, they encumber someone's land and in effect, interest therein. And the next one is going to be
This is called the easement in growth. This is also very important concept. They will test you. This is the utility right. Power line, water line, electrical, gas. Always, this is a neighbor. So the utility company, they have the right in your back, probably 5 feet, 5 inch or 5 something like that. They have some pull their line here, power line, water line, electric line, and gas line. And this is called the public utility in growth. He has a right to dig the hole in here, but you cannot use this. Because when you use this, they will have some trouble with the gas, with the electrical, and with the power. Okay. So this is called easement in growth. There's a term, special term. They will ask you what is called the utility company's right to use it. Easement enclosed. The easement enclosed does not belong to the owner. This belongs to the utility company. So when they sell in the house, the right cannot be transferred.
Right.
Okay.
It stays as that
You say
utility
that.
company.
Okay. This is the. Okay. The next.
The next one is license or permissive. A permission either express or implied. And then we have terms.
Permission is very important term. Okay. If this is the easement property, this is what easement property, that means that the road is not a public road. It's belong to the easement. When the people to go from here, so go from here, go there. So this is the easement property. You need to, they go to, when they come in, they pass this one, they pass this one, pass this one, pass this one here, right? Okay, so that they go to several different houses in the front. Okay, so they need a permission for that. Okay, so when everybody agree, when the subdivision agree, this is by permission. So you can use in the easement right to go to somebody else. Right. Okay, next.
Terms. Easement may be extinguished or terminated in several ways, including express release, legal proceedings, non-use of a prescriptive easement for 5 years, abandonment, merger of servient tenement, and the easement in the same person, destruction of the servient tenement, and adverse possession by the owner of the servient tenement. 1, expiration of their terms. 2, voluntary cancellation. 3, merger of ownership. 4, act of government. 5, changed conditions, which can include court finds that the restriction should be terminated because the conditions which the restrictions addressed have changed.
Okay, so this is the front house, this is the back house. Okay, this is the back house. So the back house has easement right using the front house, right? But if the front house, the owner, buy the property of the back house, so he owned the whole thing. Right? Even is 2 houses,
Right.
but he is the owner of the 2 property. So this easement rights can. It's called a merge.
Understood.
This is called a merge. So the test will ask you if the buyer back house by the front house, or front house by the back house, they merge together as a one owner. So that easement right will be canceled.
And then
Next is the restriction. Restriction has 2 parts. One is a public restriction, one is a private restriction. Private restriction is called CC&R, public restriction called zoning.
perfect. So yeah, restrictions. A very common type of encumbrance is the restriction, which, as the name suggests, in some way restricts the free use of the land by the owner. Common restrictions are referred to as the covenants, conditions, and restrictions, or CC&R, or the declaration. Zoning is an example of a public use restriction on the land. The first one, private restriction, CC&R. Restrictions are generally created by private owners, typically by appropriate clauses in deeds or in agreements, or in general plans of the entire subdivision. A restriction usually assumes the form of a covenant, a promise to do or not to do a certain thing, or a condition. And so this could be subdividers, mortgage lenders, government agencies, and home buyers needing means of assurance that the nature of a subdivision will remain unchanged. The mechanism most commonly used in California to assure this protection is a document known as the Declaration of Covenants, Conditions, and Restrictions, CC&R. Conveyances are subject to CC&R. Public restriction, zoning.
Because right now, the shortage of the land, so the state and the government encourage the developer to build a multi-family. They call it common interest development. like a condominium, PUD, or and also the community. Okay, so when the private developer to build a common interest property, then they must have file a CCNR to classify the people, the right of the use and the neighbor and between the neighbor.
Right.
So this called covered by the CCNR. CCNR will be filed by the developer to the Department of Real Estate for approval. Then everyone, when you buy the property with CCNR, you need to comply with the CCNR. If you don't comply, they can foreclose your property. So this is very serious. Okay. So this is called a restriction. That means you are the owner. You are freehold, right? However, you still need a subject controlled by the CCNR.
Right.
Okay, this is called a private restriction. When they test, they will ask you, what is the private restriction? You need to answer the CCNR. What is a public restriction? It's zoning. So, yeah, zoning. Next.
So the next one is zoning, which is a public restriction. Most California cities and counties have adopted ordinances that divide their jurisdiction into land use districts or zones. Within each zone, a specific set of regulations control the use of the land. There are often zones for single-family residences, multifamily dwellings, commercial uses, industrial activities, open space or agriculture, and sometimes mixed uses.
So the city will control their land use in the city. So they put a zoning. Every city have a zoning map. Okay, this certain area is residential, certain area is commercial, certain area is the industrial. Okay, in the residential area, they have R1, R2, R3. R2, R3 means you can build a more units in a high density or medium density. The R1 is the low density. That means even you have a big land, like over 10,000 square feet, you still can build only one house in there. But right now, the state passed the law. They encourage the city approved for the ADU. ADU, that means if you land big enough, they allow you to build more house, but still in R1 zoning. In before the R1 zoning, they are not allow you to build a second ADU.
So that's
but right now, yes, right now the law approved that you can build more. So this is controlled by the zoning.
Nice.
Okay. Next.
All right, and next is going to be encroachment. Encroachment. Adjoining owners of real property often find themselves involved with real estate law because of encroachments in the form of fences or walls and buildings extending over the boundary line. The party encroaching on a neighbor may be doing so with legal justification. The person who encroached may have acquired an easement by prescription or possibly by implication. On the other hand, the encroachment may be wrongful. If it is, the party encroached upon may sue for damages and a court may require removal of the encroachment.
Encroachment is very important terms you need to memorize because right now, a lot of property involved in the encroachment. Because hillside, when a hillside property, you cannot very clearly to define where is the property line. Okay, in the usually we have some wall between the cars to divide the property line, right? But in hillside, because the land is not straight, so the neighbor has a problem with the property line. If you find out your property was fenced by your neighbor, and it's called encroachment, okay, you only had 3 years to sue back. If you don't sue them back 3 years, you're gonna lose the right. So that's a very, very important point.
Yeah.
You need to memorize encroachment. Okay. Next thing, injunction.
And then we have injunction, which is also a court order. An order by a court preventing one from acting or restraining one from continuing some action.
Injunction also is a legal term. It's a very important legal term. Okay, this is also the call. Also, there is also the task question. Okay, let me give you some example. Many years ago, and one hotel in the San Gabriel, the owner and the management team, they have a legal lawsuit. Okay, this is the owner team, and this is the management team. Okay, so the owner team sued the management team because this is the hotel lost the money, poor management, and they steal the money, something like that. So the owner team sued the management team. The management team fight back. So this is a big lawsuit. This is at that time. So the owner filed the injunction court order from the court, was approved by the court. So the court granted the injunction order. So that means within 100 feet, the management team cannot go into the hotel. He cannot go in the hotel.
Like a restraining order for the property.
Right. So that this is called injunction. Remember, injunction is in the real estate. It's very, very important terms and also legal aspect. So they will give you a test. What is injunction? That means the in a lawsuit, the people fighting each other. Okay, and so they can prevent the other party get into the property. Right. This is called injunction. Okay. Next. The next is relate to the money. Relate to the money, and that means the judgment, lawsuit kind of stuff. The first part will be a general lien, L-I-E-N, lien. Okay.
Perfect. So money-related liens. First one, general lien. Encumbrances that affect title. Most notably, these are liens. A lien is defined as a charge imposed on property and made security for the performance of an act, typically the payment of a debt or promissory note. Liens may affect real or personal property and may be voluntary. An example is a home mortgage to secure a loan, or involuntary. An example would be imposed by law or overdue taxes. Or general, affecting all property of the owner not exempt by law. This could be money judgment or a lien for overdue state or federal taxes.
The lien has two kinds of lien. One is called a general lien. One is called a special lien, specific lien. This is very, very important. You need to memorize. The general lien, only two kinds of general lien. One is you owe the tax, the income tax. The second one is the judgment. Judgment, that means if you have a lawsuit by somebody else and you lost the case. When you lost the case, all your property will be subject to the penalty, subject to the compensation. Okay, this is called the general. So the general, if you've been sued, you have A property, B property, C property. All the property are subject to IRS or judgments, the fine. Okay, so this is called the general lien. General lien. Okay, the next one is called a specific lien.
Specific lien. A lien may be specific, affecting only a particular property. Example, a trust deed or a mechanic's lien on a given property.
Okay, the special lien. Special lien, that means the mortgage lien. Mortgage lien means if you have a street property, property A, property B, property C, property C. If the property A is financed by the BOA, and property B is financed by the Chase Bank, and the property C is financed by another bank. Okay, if you owe the property tax A, if you owe the insurance in A, if you don't pay the money by the property A, So the only BOA can foreclose your property on A. They cannot foreclose B, they cannot foreclose C, even you own them, all three of it, okay? So this is called a specific lien, one by one. Okay, one by one. Which one owe the property tax, or the insurance, or all the payment? So which one is subject to foreclose? This is called the specific lien. The other one is this is called the mortgage lien. All the mortgage doesn't pay, all the tax doesn't pay, all the tax doesn't pay. Also, if you have some like a construction, you add ADU. If you add ADU in this property and you didn't pay the money, okay, then the contractor will file the mechanic lien against you. Okay, they only can file the property ADU in here by A. They cannot file B and C. Okay, so this is called a mechanic lien. The mechanic lien, they have a certain rule.
Yes. All right, so for the mechanics lien is a lien which secures payment to people who have furnished material, performed labor, or expended skill in the improvement of a real property belonging to another.
Okay, this is the property you own. Because you have land, big land, okay? So you're gonna add ADU in the back. Accessory dwelling units in the back. But when you adding the ADU, you need to hire the architect to get the design. If you owe the design fee, you didn't pay for design, mechanically. Okay, then when you buy hire the contractor to build it. Okay, if you do like a builder as a contractor, so you're going to hire the subcontractor directly. Then if you owe the materials costs or the labor costs, and they will find the mechanic lien. Mechanic lien, they have a 30 days, 60 days, 90 days requirement. 30 days, 60 days, 90 days requirement. That means that if the subcontractor is 30 days, if you owe the subcontractor doesn't give them the money, the subcontractor, they within 30 days, they can file mechanic lien. If the general contractor, they have 60 days to file a mechanic lien if you don't pay the money. If the subcontractor or general contractor doesn't file the notice of completion or notice of the termination, then have 90 days. So that means within the 90 days, if you don't pay for the subcontractor and the developer, they're gonna file the mechanic lien against your property. Another one is a non-responsibility.
Yes, non-responsibility notice.
Really?
So for the non-responsibility notice, the owner or any person having or claiming any interest in the land may, within 10 days after obtaining knowledge of construction, alteration, or repair, give notice that he or she will not be responsible for the work by posting a notice in some conspicuous place on the property and recording a verified copy thereof. The notice must contain a description of the property, the name of the person giving the notice, and the nature of his or her title or interest, the name of the purchaser under the contract, if any, or leasee if known, and a statement that the person giving the notice will not be responsible for any claims arising from the work of improvement. If such notice is posted, the owner of the interest in the land may not have his or her interest liened, provided the notice is recorded within the 10-day period. The validity of a notice of non-responsibility cannot be determined from the official county records, since they will not disclose whether compliance has been made with the code requirements as to posting on the premises. If such posting has not been made, a recorded notice affords no protection from a mechanic's lien.
Okay, so this is finished.
Yeah.
Okay, so non-responsibility is a very, very important concept, okay? This is the shopping center. When a tenant leaves the shopping center to open a restaurant, the restaurant, they needed to modify. They needed to, not a decoration, modify, right? So they're gonna spend $100,000 for all the chair decoration, all kind of stuff, right? And this is the contractor do the stuff, okay? Then if you are the agent or you represent the owner, you needed to post a non-responsibility to on the door. If you don't post the non-responsibility, if the owner, if the tenant, they're gonna open a restaurant, they owe the money to the contractor. The contractor will sue the owner. So the owner will be responsible for the tenant contractor. So the owner must post a non-responsibility notice in the front door, or agent post the front door. Otherwise, okay, if the tenant owe the money, you will be responsible to pay for. Right? So this is a very, very important concept, and the task question will give you 10 days. Remember, within 10 days, you needed to post the non-responsibility on the front door. And so this is called a non-responsibility.
All right. And the next one is going to be lis pedens. Lis pedens, a notice filed or recorded for the purpose of warning all persons that the title or right to the possession of certain real property is in litigation, literally suit pending. Usually recorded so as to give constructive notice of pending litigation. Would you like me to go to the next one?
No, just 1 minute. That's pending. They are lawsuit. Okay, you can go to this 5, 1 to 5.
Oh, attachment.
Yeah.
Okay.
1 to 5. Judgment, execution, and the sheriff's
Perfect.
procedure. Yeah.
All right, so attachment. Attachment is the process by which real or personal property of a defendant in lawsuit is seized and retained in the custody of the law as security for satisfaction of the judgment the plaintiff hopes to obtain in the pending litigation. The plaintiff gets the lien before entry of judgment and thus is somewhat more assured of availability of the defendant's property for eventual execution and satisfaction of the claim if judgment is indeed awarded to the plaintiff. The purpose of an attachment is to protect a plaintiff who is in a prospective judgment creditor against attempts by the defendant or debtor to transfer or dissipating the property subject to the attachment and thus in so dissipating the property. Frustrate efforts to obtain satisfaction of a judgment subsequently obtained. The property seized and held under the attachment process constitutes as an asset of assets, which a judgment creditor may cause to be sold through execution proceedings in satisfaction of the judgment. Judgment. A final judgment is the final determination of the rights of the parties in an action or proceeding by a court of competent jurisdiction. There is, of course, always a possibility that either party will appeal, and the judgment might subsequently be reversed or amended. Comparatively, few judgments are appealed, but even for those which are not, the judgment is not truly finalized until the time to appeal or seek other procedural legal relief has elapsed. Execution of sale. Levy and execution sale. When an execution for the enforcement of a judgment is levied on a homestead dwelling, the judgment creditor must follow specific procedures. Within 20 days after a writ of execution is levied, the creditor is notified of the fact. The creditor must apply to the court where the judgment was rendered for an order to execute the sale of the property. The value of the property is determined by the court. The court may appoint an appraiser and will consider other evidences of value in order to set a minimum bid for the property. Creditors must prove sufficient value to receive the minimum bid, or the court may not make the finding for sale. If the court makes an order for sale of the dwelling upon a hearing at which neither the judgment debtor's spouse nor attorney, debtor or spouse appeared, then within 10 days after the order of the sale, the creditor must serve a copy of the order and statutory notice of sale to the debtor. The property is not sold. The property is not sold if no bid is received, at least equal to the court's prescribed minimum bid, which is a sum at least equal to the amount needed to pay all liens and encumbrances on the property, the amount of the homestead exemption, and the lien of the judgment creditor enforcing the lien. And the creditor cannot be subject the property to additional order for sale for at least 1 year.
Because a lot of lawsuits in California, in the United States. So the law want us agent or people knows the procedure of the lawsuit. The procedure of the lawsuit, the first, for example, is car accident. If something happened, a car accident, okay, somebody damaged or hurt, then the people will sue. They hire lawyers to sue you, okay? Then the first call the defendant. That means the lawyer find out you have enough property or enough value to pay for the damage. Then they're going to file a lawsuit. When they file a lawsuit, they will notify your property, file the defendant on your property. So that means when you try to sell the property, okay, then the buyer will know, oh, this property is entitled for the lawsuit, right? No. So this is the first step is a defendant. Then after it's defendant, they afraid of the owner will transfer the title to someone, to his brother or somebody else. So he needed to attach the property, will not make sure the owner of the property will not transfer title to someone else.
Okay? That's the attachment.
So that's the second step. They need an attachment, attach your property. The third step is called waiting for the judge for the judgment. If a judge find out you lost the case, you need to pay certain amount of money for the damage kind of stuff. So this is waiting for the judgment. So this is called the judgment. When the judgment is decided you lost the case, then they're going to award. The judge will award certain amount to the property, to the accident is being hurt, right? So then after the judgment, the court will exercise the judgment, try to sell your property to get the payment for the compensation. So this is called the execution. Then after execution, whoever bought a property from the court, they will get a title. This title we call the sheriff's title, sheriff's deed. Sheriff's deed. Okay. So this is the task. The question will test you the procedure of the accident. They will call you, what is the next step of the defendant? What is the next step of attachment? What is the next step of the judgment? What is the next step of the execution? What is the next step of the deed? Something like that. So this is the question they're going to ask you. What's the next step? Right. Okay. Next.
And the next one is going to be declared homestead. The principal purpose of the homestead exemption is to shield the homeowner against creditors of certain types whose claims might be exercised through judgment lien enforcement. Few areas of California real property law are more misunderstood by laypersons. Keep going to the next one.
The amount is changed already.
The amount?
Yeah, amount is changed. The homestead.
Oh, okay, all the way down to protection. Against unsecured creditor. A homestead declaration does not restrict or limit any right to convey or encumber the declared homestead. To be effective, the declaration must be recorded when property recorded. The declaration is prima facie evidence of the facts contained therein, but off-record matters could prove otherwise. Abandonment or sale. When a valid declaration of homestead has been filed in the office of the county recorder where the property is located, containing all of the statements and information required by law, the property becomes a homestead protected from execution and for sale, except as otherwise provided by statute. It remains so until terminated by conveyance, abandoned by a recorded instrument of abandonment, or sold at execution sale. The protection amount. Creditors having a right to execute on a homestead cannot be prejudiced by subsequent increases in the statutory exemption value. The statutory definition of the protected value is the actual cash value of the dwelling over and above all liens and encumbrances on it at the time of the levy of execution. In other words, the homestead protects the homeowner's equity in the dwelling. 1. Code of Civil Procedure Section 70473A has been amended effective January 1st, 1998. 2. Code of Procedures Section 704-730A has been amended effective January 1st, 1998. By amendment, the homestead exemption is raised to $150,000 if judgment debtor is a person 65 years of age or older, or a person is 55 years of age or older.
That part of the law has been changed last year.
And so that new amount is how much?
No, it's according to this one.
Oh, perfect. On here.
Homestead, California.
All right. So the homestead exemption in California was actually changed in 2020. The countywide median sale price prior to the calendar year not to exceed 600,000. And then the second ruling is 300,000. Prior years was 300,000 or less. And the third change was from 2022. The annual adjustment based on CPI.
So that this homestay is a very important concept. We needed to memorize that. The homestay, we just talking about a car accident, right? If you've been sued by a car accident, the judge grant $1 million. If the judge grant $1 million for the loss, okay, then they will execute your property. They will sell your property and get the $1 million to pay for the compensation, right? Okay. Now, if you file a homestay, they will give you exemption. Exemption, that means your property $600,000. Before it's only 50 something. Now, from last year, the $600,000 you cannot touch. That's protection you. Okay. Plus the bank. If you have a loan from the bank, another $500,000. So $500,000 plus $600,000, you have $1.1 million is protected. Right. Okay. So the judge grant $1 million. So that means your property is not enough to pay for the compensation. Is that correct?
Right.
Okay. So there's no lawsuit.
So the property would have to be able to sell for like 2.1 million for them to receive that 1 million.
Yeah. Has to be sold before above the 1.1 million, because the $600,000 is protected amount.
Right.
Okay. And you have the loan from the bank, $500,000.
Right.
Right. Total is the $1.1 million, right? So that if your property can sell for over $1.1 million,
then they can sell it.
they can sell it.
Right.
If they cannot get a $1.1 million, there's no use to sell, right? But if you don't have a loan, if you pay cash for the property, right? Or your protection is only $600,000, right?
Right.
But if your property was $1.5 million, then $1.5 million less $600,000, you still has probably $700,000, right?
Right.
It's subject to the fine.
So the remaining after that 600,000 would be subject to the fine.
Yeah.
If there's no mortgage.
If they don't have a mortgage.
What if the house sells for over all of it? What if the house sells for 2.1 million plus?
okay, that means that the, you have protection, right?
No.
$600,000, right? This is the homestay.
Right.
If you file a homestay, right? So you have first basically protected. The second is loan. Loan is, for example, $500,000, right?
Right.
Okay, so your total protected is a $1.1 million, right?
Right.
This cannot be touched. Okay. If you study whatever the amount over here, they grant you $1 million, company, right? If you're selling for 1.5,
The 400,000 goes over there.
yeah, they only can get $400,000.
What if it's over the million?
Over $1 million, okay, whatever left
Belong to the owner.
will own it.
Got it. So that equity is still protected. So if
It's
the
still
house
protected.
sells for
So
2.5,
so it depends on how much compensation the judge will grant.
perfect. Yeah, makes sense.
Make sense? So the homestay is very important parts in the real estate.
Yeah.
So everybody has to remember to file the homestay against protect your property, because this is an unsecured creditor. What is unsecured creditor? That means you don't know who's going to sue you.
Right.
Right. So that's unsecured. But you find a loan from the bank. So you bank is a secure creditor. Right? Because you know you owe the bank.
Exactly.
Right. So it's a secure creditor. But you don't know who's going to sue you. So it's unsecured creditor. So the homestay is only against the unsecured creditor. So this first component. The second one is you needed to record. If you don't record, you don't have a homestay. It's not automatic homestay.
Right.
It's only cost you about $30, roughly around $30 to file a paper. They call a homestay in the county recorder office. Then you'll protect $600,000.
Nice.
Okay, but if you have a 3 house, one at a time. You bought A house, you bought a B house, you bought a C house. You have 3 houses. This is only about $1.1 million. Okay, so you filed a homestay, right? Then you bought a second one. $1.5 million. Then you bought another one, $2.22 million. Now you have 3 houses.
Right.
Okay. Homestay only can be one.
So only 600,000.
Only one property can file the homestay
Per person.
Then if okay, not per person, per household. Okay. When you file out A, you file a homestay here, but you want to change to B. So you needed to cancel homestay of A and re-record the homestay on B. If you want to change to C, so you need to cancel the homestay in B and re-record to the homestay of C.
Understood.
See,
Yeah, it can only be on one property.
one at a time, only one. So this is the probably 2 or 3 different questions here. It's very complicated and confused question. You needed to very careful.
Yeah.
Okay. Homestay is very important part because they protect your property,
Right.
protect your safe. You know.
Yeah.
So this is the call. So there's the it's good. Right now it's the the amount is $600,000 at least. You know. In the before only 50,000, 70,000 is not enough.
Yeah.
Yeah, it's so dangerous. So this homestay concept exemption is very important. Okay, so you need to memorize and to totally understand that.
Absolutely.
All right. You have any comment for this chapter?
No, great chapter.
Yeah, this is a very confused chapter. It's scary, you know. Everybody can sue everybody. Especially you own a lot of property, you know.
Understanding this helps you stay a lot more protected.
Yeah, you will know you'll be protected. How you gonna protect yourself, you know? So this is a very very important thing. Yeah, asset protection It's a very important
Absolutely.
policy.
Yeah,
Our
definitely.
wealth is protected too.
Exactly. Yeah.
Okay, so this is the chapter 3. We call the encumbrance. Okay, then we're gonna continue to next chapter. And if you are interested to buy the books or the text, you can call the Home Times 626-585-8998. If you want to review or YouTube, you can go to YouTube or account US Home 555, US Home 555 anytime through the YouTube. Thank you so much.
Thank you.
Thank you. Bye-bye.